Today's session is, as we can see on the topic, is drafting of sales deed. And so before we jump on to sale deed, I would like you to know that this document or this session is not only going to help you understand the crux of the sale deed, but also the crux of other transfer documents. So as you can see here is that a property is getting transferred from one person to another person, and that is why we have termed the document as sales deed. But before understanding the draft of the sales deed, understanding what is all agreement for sale all about, we have to understand that sales deed or agreement for sale or any such transfer of property forms which part of the law. So as lawyers, we should be very clear in our thoughts, our expressions, so that whatever facts we have of the client are noted down and reduced into writing in a very proper and simplified way. So that is what we aim for. And we'll start with the session while understanding what is conveyance all about and what are those conveyance documents that we need to understand first, or maybe read about conveyance more. So conveyance is nothing about transportation, that is transfer of one property to another person. So if A owns a property, that property is getting transferred through conveyance to another person. And it transfers through what? It transfers through a document which is known as deed. So conveyance deed. So all such documents through which a property is getting transferred to one person to another person's name is known as conveyance deed. And sales deed or agreement for sale forms the part of this section of law, that is conveyance deeds. And the most important thing that we're going to learn is how to draft a sales deed. But before understanding how to draft, we need to understand what are the acts that we need to follow. Firstly, there is one thing that we should be very thorough with is the Contract Act. Indian Contract Act is the most important while you draft any document. Indian Contract Act, Transfer of Property Act, Registration Act, and Indian Stamp Act, the State Stamp Acts. We have to follow the provisions of all these acts and then inculcate into our drafting. I'm just going to screen share and just let you know that what are we going to discuss today. So as I said that you should be very clear while you draft. You should be very clear in your thoughts, your expression. You should know all the factual situation of your client so that you can draft a very simplified simplified document for everyone to understand. All right. So basically, these two documents we are going to majorly look at, and especially agreement for sale is what we are going to look at majorly. So these are the topics that we're going to discuss today. First one is the basic difference between agreement for sale and sales deed. This is the major part where every lawyer gets confused. Not every, as in who is not having the knowledge of it, but there is a big difference between these two documents. Then what are those important documents to draft while you are attending a client who wants to purchase a property? And then what is the basic structure of how agreement should look like? And then what are those major points that you should include in the draft, or what are those major words that you should include in the draft? And then of course, we'll start with the basic difference. So as I said that the agreement to transfer any property will always form the part of conveyance deed, agreement for sale, sales deed, gift deed, leave license agreement, or any lease deed, or a relinquishment deed, release deed. These all documents are there which forms a part of conveyance deed. We'll start with the stages first. So there are many stages. We have just shortened it to 5 stages. And whenever a client comes in and asks you that I want to purchase a property, the first thing that you're going to ask your client is where is the property and what are the details of the seller. So once you understand what are the facts from your client, you jot down the facts. When you have all the facts with you, then you start jotting down the points to be included in the draft. This is the most common mistake that we do, that we don't listen to our clients patiently. That is the most important step that you need to do, is listen to them first. Collect all the facts. Don't miss out any important small to small things also, because that is all going to get recorded in such an agreement which is going to be stayed for perpetuity. So it is very important that you understand the facts very importantly. So obviously then you are involved in the negotiations with the client, with the buyer, seller. You are there in between. You understand the terms and conditions of the buyer. You understand the terms and conditions of the seller. What is the consideration amount involved in the sales deed? And then you come up to some conclusion, and then you start with a memorandum of understanding. MOU is just a very normal document, it's called a non-legal document. It is not binding on the parties at all. It is just on a plain piece of paper that so and so flat has been agreed to be transferred from one person to another person. And this is the token amount which is being given. Let's say the flat is for 1 crore. According to the carpet area, everything is calculated, the market value and all. You calculate the consideration amount and some token amount you give. So if you are giving some token amount, then you always have to prepare one memorandum of understanding, which depends upon the parties. If there are very good relations, you prepare or you don't prepare. But as a lawyer, you should always tell your client to please prepare an MOU, so which will be very important for further transactions, further set of documents. So negotiations, memorandum of understanding is the second stage. Then comes a very important thing is the agreement for sale and sales deed. So third is the area where you start drafting the agreement for sale. Agreement for sale and sales deed, they both are very different. Agreement for sale includes, agreement for sale is a promise or it's a willingness of both the parties. One party is willing and promise to sell the property, and the other party, who is the buyer, is giving the promise or is willing to buy the property from the seller. Obviously, here we are talking about, so sales deed, agreement for sale or property transfer can be of anything. It can be of a land, a commercial property, a residential property, any office premise, anything. But today, as I said, that sales deed is a very versatile topic and it includes many properties. We are just going to concentrate on one aspect of it, and that is residential property. I practice in Bombay, so I can tell you better about cooperative housing societies and how do the transfers take place of a residential flat which belongs to a cooperative housing society. So anything which I'm explaining is pertaining to that side, that aspect of law, which involves a residential premises, which is getting transferred from one person to another. And here we again start with the agreement for sale. What does it include and what are the aspects that you need to understand first before drafting the document? So your agreement for sale is just a promise. It's a promise to fulfill in future, as in it's a futuristic agreement कि मैं ऐसा काम करूंगा या करूंगी. I am promising to pay 1 crore to so and so person in future. In future, you are promising to do something, and that promise you're giving it today. So agreement to sell involves the terms and conditions on which the sale and purchase shall be transacted. Consideration amount shall be paid. So it might happen that during the MOU, you have already decided the consideration amount. Let's say it is 1 crore. And you've already given, let's say, 10 lakhs. And then during the agreement for sale, you're drafting the agreement, and during the time of executing it, you're paying the 50%. As in including the MOU amount, that is a token amount, you are already paid 50 lakhs and 50 lakhs is remaining. So in the agreement to sell, you will mention this exact point that the total consideration amount for the said property is 1 crore, out of which 50 lakhs has already been paid through NEFT, RTGS or through check, cash, whatever it is. And the remaining 50 lakhs shall be paid within 3 months from the execution of the date hereof. So that you can also mention that you have to mention, well, the remaining amount. So this is called as agreement for sale, where a promise has to be followed in future. There's also one thing in transfer property which is called as part performance. So based on section 53A, part performance of contract, this is such a type of contract that you have already done partly. As in partly you have already paid, and partly you need to pay something in future. So on the basis of that, you prepare agreement for sale so that it remains as an evidence for you and for the client, for the buyer or for the seller, that such and such transaction has been taken place. Then third is an agreement to sell shows future transfer, as I said. And then rights and obligations, of course, are recorded in agreement for sale as well. So this is agreement for sale, which comprises of the futuristic transaction. Now, there is always one thing that you need to understand is that once a sale is forming between the transactions forming between the buyer and the seller, the most important thing is your document and how to register it. So the registration is also one of the important aspects, that when to register such kind of document. Should you register agreement for sale or should you register the sales deed? So basically what happens is in Bombay, in Maharashtra, it's a practice that as soon as the MOU is done, negotiations are done, you draft the agreement for sale. In the agreement for sale itself, you write the entire story, and how to draft it, we'll see it later on. But here the agreement for sale is registered along with the payment of stamp duty. So here it is very important that agreement for sale is drafted which includes, it's drafted in such a way that the entire history or the facts are written properly into this type of agreement, because this agreement is going to get registered. You're not going to wait till sales deed until the 1 crore consideration amount is paid. You are not going to wait till that time, because here the practice is such that you've paid some advance, you've paid some kind of consideration amount, you register the agreement, and you register the agreement along with the entire stamp duty. As in, you will not pay stamp duty only for 50 lakhs which has been paid, but you will pay the stamp duty on the basis of the entire consideration amount. And once the transaction is done, once all the money is paid, then comes the time of sales deed. So here, let's not get confused between agreement to sell and sales deed. We have understood what a sales deed is for about. It is for futuristic transaction. Once some kind of amount is paid, you go to the sub-registrar's office, register the document, and wait till the time buyer pays the other half of the consideration amount. And once the buyer pays the other half of the consideration amount, then comes the time of executing a sales deed. So sales deed is nothing but the actual transfer of ownership rights. So once agreement for sale is entered, it is a promise to fulfill in future. The promise which has been fulfilled in future is now getting recorded in the sales deed, which says actual transfer of ownership. So here basically it says that so-and-so was the consideration amount, so-and-so was paid, 50 lakhs was paid earlier, 50 lakhs is getting paid today, the entire consideration amount is paid, and after the full and final settlement of the amount, the transfer is getting placed immediately, as in the entire right, title, interest of the person, of the seller, is now getting transferred on actual basis on today's date to the buyer. So here the sales deed is an actual transfer of ownership which is happening in the present day, and agreement to sell is a futuristic transaction. There are some people who directly, after paying the entire consideration amount, directly they jump onto sales deed, but it happens very rarely, because properties in Bombay are not less than 50 lakhs. They start from 50 lakhs to 1 crore. It goes so on and so forth, and nobody pays the entire amount in full and final settlement in one day only. So obviously there are steps which are getting followed. So first you do the negotiations, then you do the negotiations, then you do the memorandum of understanding, you draft the agreement for sale, you ask the client to pay the stamp duty, and then within some time of paying the stamp duty, you go to the registration office, you execute the agreement of sale, wherein some part of the consideration amount has already been paid by the buyer, and the remaining amount shall be paid within 3 or 4 months or whatever. Within 90 days is the ideal time, which is to be written in agreement for sale. And then you execute the sales deed. So here in Maharashtra, the registration of agreement for sale is very important. Now you might ask that, is it necessary to register the sales deed as well? Well, 99.99% nobody registers a sales deed. It's just a piece of paper where both the parties agree upon terms and conditions that whatever the consideration amount was there, it was full and finally settled. It has been paid through so-and-so cash, check, RTGS, NEF, whatever it is. And now the delivery and the possession of the property is now getting transferred to the buyer, which is written in the sales deed. So why it is not important to register a sales deed? Because you have already registered once both the parties along with witnesses have been present in the sub-registrar's office. They have already done the registration work. They have already shown the original documents, original chain of agreements, which we will discuss about later on, of course. And they have already paid the stamp duty for the entire consideration amount. So again, paying the stamp duty is not what law asks for. Government is only concerned about the payment of stamp duty. Once the stamp duty is paid on the transfer of property, that's it. Government is satisfied enough. So again, you don't need to go and register the sales deed. But yes, once the entire consideration amount is paid, you have to execute a registration. You have to execute a sales deed. With or without registration, it's your choice. If you have money, you can go to the registration office and pay the registration fees and register the document, but it is not important. So now we understood that what typically 5 stages of a sale transaction looks like, and what are the documents that we need to prepare. First one is the MOU, which is a non-binding, legal contract. It's just an understanding between two parties. It does not have to be more than 10 lines. Trust me, people make MOU as if they're making agreement for sale and sales deed, but it is not important to make such agreement. It's just a mere exchange of understanding between two parties. Then we come for agreement for sale, then sales deed. We'll understand what agreement for sale should look like. Okay, now the parts of an agreement, of course, these are the parts which any agreement should look like. It's not about just sales deed. Even if you're drafting any commercial contract for any client or any kind of contract, let it be sales deed, let it be gift deed, release deed, relinquishment deed, or any business contract, anything, these four parts are very, very important. This will always be there in any agreement. So first one is the preamble, then comes the recitals, clauses, and signing and sealing it. Now, most important thing that I'm going to say is I'm going to concentrate more on preamble part and the recitals part. And the recitals part is also very important. Actually, it's most important of all of the clauses. You will know the reason why. So now let's jump on to what a preamble should look like. Preamble is the title of the property. As in, of course, the clients are going to come in, they're going to share their name, address, everything. That is very important. If my name is A, I have to be A. I can't put my name as AB. I have to be that sure that even the first name, second name, and the surname is exactly how it is there in your Aadhaar card or PAN card. So your identification proof will play a very important role in the preamble. How your name is placed in these documents, the same way you have to place it in your agreement as well, in your client's agreement. So now first one is the title of an agreement. Okay, that is agreement for sale. We are actually looking at agreement for sale, the middle part of the transaction, which is going to get registered before the sub-registrar's office. So now we have understood about the title of agreement, then the abbreviations, date of execution. What is meant by abbreviation? If I say my name is Mohini Ajay Kumar Maroo, then I will just write MM, or the first party, or party of the first part, or I can say vendor, or I can say seller. And then the same will go for the buyer, and it will same go for the other things that we'll discuss later on. First, the title of the agreement, then the abbreviations is very important. Date of execution. Date of execution is the date on which you are registering the document and not when you have drafted the document. So whenever you are drafting agreement for your client, always keep the date blank. Just write the month and the year, but keep the date blank, because when you're going to register the document, that day you have to record in your first line of the agreement as well. Place of execution, of course, very important, and names and addresses of the party. This is how a preamble should look like. I'll just give a minute. You can go through it. Okay, so it is always advisable that you use the word vendor and buyer. You don't use the word vendor and vendee, because then you will get confused. You should always write either the opposite words, as in if you're using the seller, then use the word buyer. If you're using the word vendor, then use the word buyer, but don't use similar kind of words for both the parties, because it's just going to get confusing. So here you have to mention the name. The residential address is very, very important, and the identification proofs are very important. Here I have not mentioned the PAN card and Aadhaar card, but here you have to mention on the first page, because here the first page is going to be very important. And based on that, the last page, of course, will again be the identification of the of the same parties. So here the name and date, everything is mentioned. Now, how to choose the title? Of course, this is very important. You have to know the nature of the transaction. If I am only preparing the document for the middle stage of the transaction, let's say I'm preparing a document which consists of futuristic promise, then I can't term it as sales deed, because sale deed is something where there is actual ownership of document or actual ownership of the property which is getting transferred. But if it's an agreement for sale, if there's some part of consideration which is left to be paid, then you have to choose the title according to the intention of the parties. So intention is very important. So if let's say if you have made a mistake, let's say you have termed it as sale deed. It's a very common thing that happens. Let's say it's actually agreement for sale, and you have done a mistake and you have written the title as sales deed. Is there a difference going to be made? Actually, there's no difference which is going to be made. But then the intention of the parties is very important. So let's say if you have mentioned the word sales deed, the parties can't say that you have mentioned the title as sales deed. Now the property is actually transferred, the payment is also transferred, everything is done because you have mentioned the title as sales deed. It is not like that. Still, it will be considered as agreement for sale only. But since we are professionals, we have to be professional in all ways. We don't have to make a mistake. It's a very silly mistake that we always do. So you have to be very sure that what is the intention of the parties that should be reflected in the title. That should not be missed out. So the content of the document is important, not the title. Then comes the recital part. As I said, that there are 4 parts. One is the preamble, which we have already finished. We come to the recital part, which is the most important part because this is going to prove the title of the buyer, the title of the seller, the ownership of the seller, and the genuineness of the seller. Whether the seller is correct or not, whether he is genuine or not, it is just going to be based on the recitals part. And before the recitals drafting, you have to make sure that you have all the documents required in the sales transaction. Well, if let's say there's a property in Goregaon, and there are a lot of old buildings in Goregaon. If you see, there are buildings which are more than 30 years old, and there are many transactions which have taken place for the same property. A has bought from B, B has bought from C, C has bought from D. So there are 3 transactions here, A, B, C, D. Now D is purchasing the property from C. C has purchased the property from B, and B has purchased the property from A. So there might be 3 agreements in it between A and B, B and C. And now the new one will be C and D. So here D goes to C and says that I want to buy your property and I want to see the chain of documents in it. And C says, yes, I have purchased it from B. You can see it. So he provides a document which he has purchased from B. But B does not have that document which says that he has purchased from A. So here the chain of document is very important. So it might happen that B has taken the documents fraudulently from A and then sold it to C, who is going to verify it. So here the chain of documents is very important. So as a lawyer, once a person approaches you, once a client approaches you, you have to ask the client how old is the property and how many previous buyers were there for the same property, how many original owners were there for the property. And then you have to look at the chain of events which has happened in that property. It might happen that the property is ancestral. It might happen that A was the ancestor of B and he actually never purchased from A. It might happen that through a release deed, the property was transferred from A to B, then from B to C, there was actual sale transaction, and now the new transaction is getting created between C and D. So where is the release deed? Where is that registered release deed that you have to ask the client? Because if you don't have it, then you can't enter into a new transaction. So the importance of chain of document is very important. So that you have to include in the recitals. Recitals is nothing but a story. If there is a residential flat in Goregaon, there must be a story behind it. The story is what? The chain of agreement. Who was the first owner, second owner, third owner, and who is going to be the fourth owner. That is all written in the recitals. You show the background, you show the summary, you show the history of it. It is not only important to just write the history that A was the owner, then he died, then the property was transferred to B, then B sold it to C, now C is selling it to D. It is just not important to write that. You have to write when it was registered, the registration number, the entire schedule of the property should be written very thoroughly. The CTS number, what are the boundaries of the flat, north mein kya hai, south mein kya hai, east mein kya hai, west mein kya hai, when was the building formed, who was the builder, then so on and so forth. Right from the birth of the building till date, how old is the building, the entire story and background you should include in the recitals, which is very, very, very important. So now the recitals are of 2 types. One is in narrative recitals and one is introductory recitals. So once I say that you have to draft an agreement, it's just not randomly you have to write the agreement. You have to properly form the agreement from the preamble to recitals, then clauses and signing and sealing it. So in recitals also, there must be a chain of agreement that you should enter according to chronological order and not just in any manner. So narrative recitals is nothing but the story. A gave it to B, B gave it to C, C gave it to D. And now what is happening? Now C is giving it to D. So C is selling the property to D will be the introductory clause. And the narrative clause will be the history, the chain of agreements. So these are the recitals that you should write in the agreement. Why I am putting so much pressure on the recitals? Because first, it will show that the seller has clear marketable title towards the flat. you have to enter these words in the draft that the seller is having a marketable title towards the flat. The flat is without any encumbrance. Without any encumbrance, as in there is no loan on it. It is free in the market to be sold. There is no other person who is going to claim on the property. There are so many times we encounter these situations where the client comes in and they say false that this property is mine and we want to sell it to the other person. Though the property is into their name, but how did the property come to their name? They will never tell, because in society what happens is the society will issue the share certificate. But if the property is getting claimed by some other person, let's say the property is an ancestral property, the ancestors died, let's say the father and mother, they are no more, but the father and mother, both husband and wife, had 3 children. One of the children was staying in the flat. He was taking care of the parents and all that. So he thought that the flat will be his. But the other 2 legal heirs, after the demise of the parents, were now claiming the property. But this third person was already staying in the flat. The third child did not listen to them. He fraudulently transferred the flat in his name. So here in this case, when some other person is already claiming the flat, in that scenario, you have already transferred the flat in your name, then such title to the property is not clear and marketable, because the property is in dispute. As when the property is in dispute, the property cannot be sold to any other person, nor you can acquire any loan on that. That is also very important. So here the client comes in and says, the property is in our name. And then when we try to ask them what are the chain of documents, they will show the chain of documents that my mother and father, they bought the flat and so from so-and-so builder. Builder is also having the leasehold agreements from the landowners. Everything is clear. But then when we try to answer, we try to question them, who are the other legal heirs? How did you transfer the flat? Then they say that we just have the share certificate in our name. That is not so. So the clarity should always be there, that was there any release date, was there any probate which happened, or if there was no probate, then is there any letter of administration? That is all you should know. And once everything is clear, then you can mention in the recitals. So recitals play a very important role as because they form a part of corroborative evidence also. So if there is any breach of contract, breach of sale agreement, and then the dispute goes into the court, then of course the recitals can be used as a corroborative evidence. They are not the evidence, because obviously you should have original documents to support it. But if you don't have original documents to support it, if you just have the information, it can be termed as a corroborative evidence in the court of law, subject to the judgment or subject to the order of the court. So here are the narrative recitals, which look something like this. As I said, narrative recitals are the history of how the flat was transferred from one person to another. So here are the narrative recitals. You can just have a look, just go through once. So the vendor is the owner. Occupant had exclusive possession of the premises, so-and-so, and now it is going to get transferred to so-and-so person. This was the original agreement. Then the chronological order, then it transferred to some other person, then to some other person, just happened in that way. And then these are the introductory recitals, which is happening now. What is happening now? That C is giving the flat, selling the flat to D. So those are the introductory recitals. And that D has already verified the entire property. He is clear with the market and title. And now he is acquiring the flat through the sales deed, through the agreement for sale in this case. So these are narrative and introductory recitals that you should know. Then comes the clauses. So clauses, again, follow the terms and conditions. They follow the terms and conditions of the agreement for sale, as in they will include the consideration part, of course. How much is the consideration amount which is going to be exchanged from the buyer, from the seller to the buyer, from the buyer to the seller, whatever it is. And then the payment, how the mode of payment is going to be. What are the representations and warranties? What is the seller promising to do? What is the buyer promising to do? Are they telling the truth or not? Everything will be included in the representations and warranties. Indemnification clauses will be included in it. Then there will be force majeure clauses. Lot of clauses. We'll see all the clauses. So clauses again are of 2 types. As I said, the agreement should follow chronological order. Once we did the preamble, then we did the recitals, which will include the narrative recitals, the introductory recitals. Then comes the part of clauses. So here the clauses again will be operative clauses and boilerplate clauses. Operative clauses should include operative words. As I said, it should include the words such as the buyer has got clear and marketable title, sufficiently entitled to sell the flat legally to the buyer. So that all you need to be you need to include in it. You should also include the words such as the seller is in full use, occupation, and in exclusive possession of the flat. Exclusive possession as in only that person is having the possession of the premises and not some other XYZ person. So exclusive means that only you have, and you're going to give their exclusive possession to the buyer. That means only buyer in the next stage of the transaction is going to have the possession of the flat, which is very important. So use, occupation, exclusive possession, these are the words that you need to include in the draft. So these are the operative clauses. Boilerplate clauses, we'll understand the difference. Operative clauses are the general clauses. That's as in you will enter the facts of the present case, which will change from every case to case. As in, if there is a consideration amount of 1 crore, there might be a consideration amount for the other flat. I mean, there will be a different consideration amount for other properties, not the same. So it is going to change. Rights and obligations of the parties are going to change. What the buyer is going to do shall change. When the buyer is going to pay the money is going to be different in every case. So here the transaction, rights and obligations, conditions precedent. Conditions precedent as in, okay, so there are a list of documents that you need to procure. Let's say if you are entering into a sale transaction, there are a list of documents that you need to procure, either from the society or which you already have. You have to show it to the buyer. So when a sale transaction is getting executed, the major role is played by the society, because you need to get a permission from the society that whether the seller can sell the flat to the buyer. So here in agreement for sale, it is always written that there are conditions precedent. Before the sale transaction takes place, the seller has to obtain an NOC, that is non-objection certificate, from the society, saying that the society has no objection if the seller sells this flat to some buyer. Why is it done? Because again, I said that the seller should have a clear marketable title towards the flat. Let's say if the flat is in a very good society, let's say it's in some society of Lodha or Rustomjee, which is a newly built societies. So here the maintenance amount is too high. Let's say 5,000, 10,000 is minimum maintenance that you need to pay for a 2-bedroom hall kitchen or 3-bedroom hall kitchen. So let's say the seller, who is the owner of the flat, just wants to get rid of the flat, is still in the liability to pay some 1 lakh amount or 2 lakh amount of the maintenance bill, of the society maintenance bill, and he is not paid off. The society will not issue the NOC, or he has done some kind of breach towards the society, or he's not honored some guidelines of the society is not going to give the NOC. So in this case, there are certain conditions that you need to write, that if the society is not satisfied with the seller, if he has not paid the maintenance bill, the buyer will make sure that it is written in agreement for sale that all the society maintenance bills shall be cleared, shall be paid off by the seller before the execution of before the payment of the full and final settlement of the consideration amount. So this is one of the just examples of conditions precedent. So you have to follow this. There are a lot many documents that you need to procure: PR card, so the commencement certificate, occupation certificate, OCCC, property card, municipal taxation bill, the original chain of agreements. These are lists of the documents that you need to procure. So these are the conditions precedent that you need to follow. So this is all written in the agreement for sale. Rights and obligations. What are the representation and warranties? So the buyer, if there is any discrepancy in the flat, if there is any leakage in the flat, or if there is any major defect in the flat, that has to be shown to the buyer by the seller. If there is any ongoing loan on the same flat, that has to be shown to the buyer. That has to be clearly made available. The information should be clearly made available to the buyer, that the flat is of 5 crores, but we had taken 2 crores loan from the bank. You have to show it, because if you don't show it, you are actually cheating the buyer. So that representations and warranties should be clearly written, that you actually have clear and marketable title to the for the flat, and that you are indemnifying. That you have to write the word that here the seller is indemnifying the buyer, that whatever loss, claim, or damages which arise in future because of the mistake of the seller, the same shall be, the seller shall indemnify. That is he will pay off. That is, he will pay off for all the damages, claim, claims or losses which the buyer has suffered from the mistake of the seller. So representations and warranties, indemnification clauses, rights and obligations, transaction points, consideration points, these are all the points which form the operative part of the terms and conditions of the sale agreement, agreement for sale. So that you need to understand, that you need to be very thorough with this. There is also one thing that I need to share, that the address of the flat or the names of the parties, the area of the flat, the carpet area or the RERA carpet area should be clearly mentioned properly. Because if you do this mistake, and if instead of flat A1, you write in such a way that it sounds A11, then it will be your biggest mistake, because you have not sold the flat A1, you have sold the flat A11, of which the buyer does not have any right to do so. So this is very important, where you need to be very thorough with your investigation. You listen to the client very properly, and you jot all those points very properly in the drafting. Because like how CAs audit the accounts and taxation thing, in the same way we have to vet the documents and write the vet the documents and write the draft. I mean, draft the document in such a way that there are no mistakes in such factual situations, factual information. If the flat is mentioned, the number should be properly mentioned, area should be mentioned, CTS number is the most important thing that you should mention very properly. And all those things, the schedule of the property should be as it is printed on the original sales agreement. If there is any mistake, then you're gone. You have to do again the entire thing. That might happen that even if you go for rectification deed, the registrar might not even accept such rectification deed, because they might say that you are fraudulently selling the other flat as well without payment of stamp duty. So just to evade the stamp duty, the registrar might not even accept your rectification deed, how much ever properly, how much ever genuine you are, how much ever genuine your clients are. So you have to be very thorough with the drafting work. So transaction rights and obligations, conditions precedent, representations and warranties. Then there are other clauses such as handing over of the possession property. So you have to again mention the word that peaceful and vacant possession. Peaceful and vacant possession shall be handed over to the buyer from the seller after the full and final consideration of the entire amount. So peaceful and vacant possession, these two words are operative words that you should include in the draft. Then there are default and dispute resolution clauses. It might happen that even after registering the entire agreement for sale, you pay the entire stamp duty on the entire consideration amount. It might happen that the buyer defaults, or the seller says that I don't want to sell the flat anymore. So now what happens is that you are breaching the terms of the contract. A legally binding contract, you have breached the terms. So here you can specifically enforce the contract. You can either go to the court. If there is an arbitration clause which is mentioned, you follow the arbitration. If not, then you can go and file a criminal case or civil case, whatever is suggested. You can do that. So default and dispute resolution clauses are very important, because still the agreement for sale is not full and final settlement of the transaction. That is important. Force majeure clause is nothing but, how do you say, खुदा ना खास्ता कुछ हो गया तो, act of God. So if there is an under construction building going on, the building was supposed to be 22 storied, but the construction stopped at 15 floors only because some earthquake happened. So in this case, what will happen is that, so these are the force majeure clauses, and you need to enter that if the construction is stopped in midway, or the transaction is stopped in midway because of the fault of some third party. There's no fault of the first or the second party. There is some act of God which happened through which the transaction was cancelled. So in this case, what will be the damages that need to be paid off by both the parties? That all is written. So these are the force majeure clauses. We discussed about the operative clause and the boilerplate clause. Whatever I discussed were the operative clauses. Force majeure clause, dispute resolution clauses, these form the part of these type of clauses form the part of boilerplate clauses, which don't change in most of the cases. In 99.99% of the drafts which you make will not be changed. As in, if there are boilerplate clauses, you won't change the boilerplate clauses, because they will always be as it is. As in the governing jurisdiction, the arbitration point, force majeure point, this will always stay as it is. So you don't need to change it for every draft. What is important is the recital point, the preamble point, and the clauses. That is the operative clauses you need to look at. So this is what we discussed. Then comes the signing and sealing part. Of course, as I said, that once you go for registration, before you go for registration, you should be very thorough with your your draft. Everything should be proper. Not even a single mistake should be there in the draft, because again, you can't call the party and then waste your hour and two in the registration office, because as it is, they're already frustrated because there's so much time which is gone in registration office. So your draft should be very perfect, along with all the annexure of the documents. As I said, there are a list of documents which are required during the sale transaction that you should have, and whatever recitals you have mentioned, you have to annex them. Let's say the chain of agreements, there are 4 chain of agreements. So each chain of agreements should have this word, this sentence in the end, that hereto marked and annexed as annexure A, B, C, D. Like this, you have to annex in the sale agreement for sale. There will be signature page. Signature page is very important. In that page, you need to give the exact same name which you have entered on the title page, the preamble page. That can't be different. If my name is Mohini Ajay Kumar Maroo, I have written Mohini Ajay Kumar Maroo in first, then I can't just write Mohini Maroo in the signature page. That has to be same. The registration witness, I think there are 2 witnesses, that the names of the witnesses should also be mentioned along with the addresses. There should be space to stick photos, and there should be space to write the PAN card numbers and Aadhaar card numbers during the registration time. So execution is very important. About the stamp duty, yes, if you have paid the stamp duty, you can write in the agreement for sale that the stamp duty has been paid. If you have not paid the stamp duty, then who will bear the expenses of the stamp duty? That is also written in the agreement for sale. So that is there. And once you draft the entire thing, you recheck it, you give for rechecking, everything happens. The registration is done, the agreement for sale is done, the 50 lakhs is done, 50 lakhs is remaining. Then within the 3 months time, the 50 lakhs is also paid. Now what? Now there is time for sales deed. 99.99% the clients do not register the sales deed because it is not necessary. You've already registered the document once. You've already paid the entire stamp duty. But there is a necessity to at least make a sales deed and notarize it. At least you should have one proof that the payment was already done. The payment is already done. I'm talking about the sales deed now. Agreement for sale is over. I'm talking about the sales deed. In sales deed, as I said, there is actual transfer of ownership, as in the document is having those clauses which says that the consideration amount has been paid already, the possession has been given, vacant and peaceful possession has been given. Now there is no liability of buyer towards the seller, and there is no liability of the seller towards the buyer, and now the transaction is complete. That kind of sales deed is made. So in the sales deed, you have the option to write the recitals. If not, then also it is fine. You can just say about the consideration and the payment terms. That's it. So this was all about the agreement for sale and sales deed, how to draft it, what are the types, what are the parts of an agreement, and how to chronologically place your client's factual situations in the draft and execute it properly. So this was it for today. If you have any questions or something, you can put up.
My question is, if full stamp duty is already paid on the sale agreement, what is the stamp duty which would be payable on the conveyance deed if it is made?
Once, I think conveyance deed is the agreement for sale.
No, so the second document to which you made a reference to, the sale deed. Yes.
No stamp duty you need to pay on it, because you've already paid the stamp duty for agreement for sale. And these days, what registrar do, they don't accept only the agreement for sale if your stamp duty is not paid. You have to pay the stamp duty and register the agreement.
Thank you.
Yeah. Can you please share the list of docs to be annexed? It depends actually on property to property basis. So if I talk about the residential properties, then I've already mentioned this OCCC copy that the society is going to provide is already mentioned in the original sales agreement, and the PR card, maintenance bills, society maintenance bills, electricity bills, PAN cards, Aadhaar cards of parties, the original chain agreements that you need to annex. Any books you suggest to master drafting of agreement of sale other than Conveyance by Divakar or Tejuriwala? You don't need to read any books for enhancing your drafting skills. If you just want to enhance your drafting skills, read one judgment every day. Let's say if I have given you a topic today of sales agreement, just type this on Google, landmark judgments on agreement for sale or registered agreement for sale, and just start reading it. That is more than enough. You don't need to read any books for it. May you please elaborate on boilerplate clauses? Yes, of course. Boilerplate clauses, as I said, these are the clauses which don't change much. It will include the severability clauses, let's say, or it will include the force majeure clauses, which says, or the jurisdiction clauses. If both parties are from Bombay, or one is from Delhi or one is from Bombay, then you will write like that: the jurisdiction shall belong to the courts of Bombay. So these don't change. If there is a breach of contract and if you want to serve the notices, those clauses are also written in the agreement. So those are boilerplate clauses. They won't change much.
यस मैम, मुझे ये पूछना था मैम कि अगर सपोज आई हैव मेड एग्रीमेंट टू सेल और उसमें पोजीशन का डेट कोई भी मतलब कोई भी पर्टिकुलर डेट है, लेकिन रेरा ने उसका एक्सटेंशन दिया हुआ है, सो व्हाट विल बी कोर्ट में क्या एप्लीकेबल होगा? रेरा का 1 साल का जो एक्सटेंड हुआ उसका, या जो एग्रीमेंट ऑफ सेल पे जो उन्होंने डेट दिया है वो उसका माना जाएगा कोर्ट इन द कोर्ट ऑफ लॉ में?
This is the dispute which happens actually, रेरा का और इसका, they will always extend it. 1 year वो लोग extend करते ही है. अगर कहते हैं कि 3 years में अगर मिल जाएगा आपको, और उसमें उन्होंने क्लॉज लिखा है कि 1 year shall extend, that will extend. So that is all. वो आपका dispute कोर्ट में ही जाएगा और वो कोर्ट ही आपको डिसाइड करके बोलेंगे कि आपके हिसाब से क्या होना चाहिए. Because unless the building is not made, obviously you won't get the possession. But then you can't default on the contract as well, so you can enforce the contract.
Yes, okay ma'am. Yeah.
Sale deed is to be notarized from notary who maintains register. All notaries maintain register. So if the notary is saying that you won't get a register number, so you have to say the notary that it is your duty to give us the register number. So you have to go to the notary and ask for the registered sale deed. So you will get the serial number as well. As I said that since today's video was drafting, on drafting, what I would suggest is that read every day as much as you can, only the judgments, don't buy books and all that. And since it is the new thing is going to come up, that is AI and the chat GPT and all that, so it's going to help us as lawyers. So just you should know the law perfectly very well. If you know the law and if you know the key words, if you know the operative words, as I said and explained in the video also, so that is good enough. And then you are good to go. And just more of judgments you read, better it will be.
Okay, Mohini,
Yes.
on behalf of the PLEA team and the participants, we extend a hearty gratitude for conducting such a wonderful webinar. Thank you so much for providing the practical insights. Thank you.
Thank you so much for having me here.